The Honorable Judges of the United States Court of Appeals in and for the 7th Judicial Circuit. Hear ye, hear ye, hear ye. All persons having business before this honorable court are admonished to draw near and give their attention, as the court is now sitting. God save the United States and this honorable court.
Good morning, everyone. We are pleased to have you here, and we are delighted to start our work today with case number 1. This is a consolidated appeal number 233159, 233175, 233340, 233363, and 233385 Elkins versus Southeastern Indiana Health Management. We welcome to the podium Mr. Carney.
Thank you, Judge. Good morning, Your Honors.
Good morning.
May it please the court. I am David Carney. I'm here on behalf of all the consolidated appellants. I represented Sarah Bush Lincoln below, and for better or worse, they've all got me this morning. So this is actually the third time I've done this. So I'm somewhat uniquely positioned in that respect, if no other. And having been through this, I wanted to start the argument this morning just by kind of level setting on why we're here and why we think these cases are removable. And obviously that starts with the complaints. The complaints are very similar, all 5 of them. I picked Goshen as the one representative example. It's App 292. I'm going to start with App 296 at paragraph 8. A pixel, also referred to a tracker or a tracking technology, is a snippet of code embedded into a website that tracks information about its visitors and their website interactions. When a person visits a website with an embedded pixel, the pixel tracks events, such as pages views, buttons clicked, and information submitted. 47, then, App 304, talking about button click data, includes any buttons clicked by site visitors, the labels of those buttons, and any pages is viewed as a result of the button's links. And so the substance of the complaints is that those disclosures of those buttoned clicks are privacy violations under Illinois or Indiana state law. And paragraph 161 of Goshen says it, App 328, defendant's disclosure and the substance of the nature of those communications is an intentional intrusion upon plaintiff's solitude or seclusion in their private affairs. And that's where we think this case is removable, because one of those buttons, and it's an important button, the patient portal login button, was something that the federal government asked us to put on our websites, and that we assisted the federal government in putting on the website. So on the one hand, we have the federal government saying, give patients and their caretakers immediate access to their healthcare information online. This is what we want you to do. We want you to give your patients the ability to click on that button.
Did the federal government ask you all to put the pixels there?
They did not, Your Honor. And I think I'd point the court to Baker on that, this court's opinion in Baker. The companies did not need, and this is 962 F3rd at 944 to 945, the companies did not need to allege that the complaint of conduct itself was at the behest of the federal agency. It is sufficient for the acting under inquiry that the allegations are directed at the relationship between the companies and the federal government.
Is it difficult to allege such a relationship between the pixels and the federal government when we have the federal government saying there's a problem with these pixels, there may be a HIPAA violation, we don't encourage the use of these pixels? We see that in the record as well.
I think that's correct, Your Honor. That was December 1st, 2022, and I think that was the first time that the federal government had said, we see a problem with this. Before, and I think subsequently, what we've seen is companies taking action and healthcare providers taking action to now deal with that regulation. But until that was the initial guidance on the tracking technology on December 1st, 2022. So we're all dealing with that, but until that time, there wasn't any guidance on this. And so that goes back to what I think really there was kind of this collaboration, and it's still a collaboration up to this time, between healthcare providers and the federal government.
I guess, Mr. Carney, it's, you use the term collaboration. Some people might use the term requirement, mandate, regulation. What's the rule that you would like us to articulate with regard to when a regulated industry, or such as the healthcare industry, that is regulated by the government and mandated to do certain things, when does that relationship cross the line between a regulated industry like Martin and something that brings us closer to the defense contractors that are making, parts for F-15s for the military to use? I think we can all agree that that's one end of the extreme, right? Mm-hmm. Martin kind of provides us with a regulated industry. And so what is the rule that you would have us propose as to where to draw that line in between those extremes?
I think the rule starts, Your Honor, from my perspective, with Watson, and the touchstone of Watson being assistance, that what you're doing is assisting the federal government in accomplishing a federal mission.
But all regulations are designed to further some sort of government goal and policy, or else there wouldn't be regulations, right? So, for example, the reason why the government regulates car emissions is because there's a federal policy that they want to further clean air, right? So if a regulation is not supported by some policy, then it would be arbitrary and capricious, and therefore it'd be stricken down, right? And so the very fact that there's a policy doesn't get you there. And so what gets you there in this case?
In this case, and I think to build on the answer, 551 U.S. Watson, the assistance that private contractors provide, federal office goes beyond simple compliance with the law and helps officers fulfill other basic governmental tasks.
Is this a basic governmental task, counsel?
It is, Your Honor. I think it has this. There's no question, Judge. I agree. It has a little bit of a know it. I know it when I see it. Feel to it. The cases I think have to be decided on their facts. To me, I look at this case and I say this should be in federal court, and it starts with this isn't compliance with the law. This is App 706. This is a federal health IT vision and mission, a health system that uses information to empower individuals. Mission to improve health and healthcare for all Americans through the use of information and technology.
But the complaints are all about the health systems, your clients' public-facing websites. And as you reminded us this morning, only one of the buttons is the button that leads to the patient portal, okay? So how are these public-facing websites, where most of the pixels are located that are complained about in this case, assisting the federal government in any function? The health systems would have had these websites regardless. It's good business to have a website for your massive health system.
And I think, Your Honor, I don't disagree with that, except in the we had websites before meaningful use. We would have websites absent of meaningful use. The one thing under Baker, again, is the 28 U.S. 1442A1 creates kind of a species of supplemental subject matter jurisdiction. If one piece of the complaint is sufficient to justify removal, one claim is sufficient to justify removal, any piece, that provides jurisdiction, federal jurisdiction over the whole complaint. So I think I don't disagree with the premise of Your Honor's question. I think, that the public websites are not what brings us into federal court. It's that patient portal link that brings us into federal court. But that aspect of the complaint under Baker and is sufficient on its own to justify removal of the whole thing.
Mr. Carney, is there a case you can point to where the court has found arising under removal jurisdiction where in the end the government did not ultimately own the end product? That is, here, I'm sure your clients would agree that the government doesn't own your websites and the government just can't come and take your portals. And so the benefit of the portals inures to, right, your client possesses the property right to those portals. Is there ever a case that you can point us to where a court has found arising under jurisdiction in that context where the government didn't, in the end, own what was produced?
Your Honor, I'm thinking of the Rural Electric Administration, REA cases, Caver, Butler, where, the federal government designed a program to provide rural electricity, and, at the end of the day, the complaints were over distributions that were being made allegedly in violation of state law. So I don't think the government owned, the rural electric cooperatives in those cases, but the rural electric cooperatives were assisting the federal government in providing and accomplishing a federal mission of providing rural electricity to those areas. So those are one case that I would cite there. The one final, I think I'm at, I just want to end real quick before I get, and I know I'm kind of into my rebuttal time, but I think on the the basic kind of this was a governmental task, to me, you will have better, this is app 792, how to optimize patient portals for patient engagement. You will have better success meeting meaningful use requirements for stage 2 if you integrate a patient portal effectively in your practice operations. The 2014 10-year health information from care delivery systems should be easily accessible to individuals and empower them to become more active partners. This is app 527, the 2022 plan. In today's digital world, patients' right to control their health must include the right to access and control their health information. So this whole record that we've established from my perspective about individual access to online information being a key component of this, I think is what kind of draws that line from kind of crosses that Watson threshold wherever it lies. So I'll save the rest for rebuttal. Thank you.
Thank you, Mr. Carney. Mr. Sokoloff, am I pronouncing that correctly?
Can you move that clock to the left so I can see it? Thank you.
Thank you, Your Honor. May it please the Court, Eugene Sokoloff for the appellees in each of the consolidated appeals. I'd like to make sure that I'm useful to you this morning if I can be. I'd like to start with 3 quick points and then just get to some of the questions that you all have been asking my friend on the other side. The defendants here point out that the question is whether a private actor is assisting the federal government. And I think the critical question that we're missing the answer to here is assisting with what? Under Watson, the question is whether the private actor is producing something that the government needs for itself, like arms or chemicals that are wartime material, or doing something that the government needs and would otherwise do for itself, like driving federal agents to a raid on a distillery. The Third, Fifth, and Eighth Circuits had no trouble concluding that building a website for a private hospital is not one of those things. I think, Judge Lee, to your question about whether the government owns the product on the back end, I don't think ownership is necessarily strictly required, but the Caver and the other rural power cases, even though the government didn't own the end product, those were deemed instrumentalities of the federal government. So you're talking about a much more closely related end product, one that is, if not owned by the government, at least deemed to be an instrumentality. The second point I want to turn to is the question of a limiting principle, and I think, again, this is something that came out in some of the questions to my friend. I don't see a limiting principle. I didn't hear one this morning, and I didn't read one in the briefs that would allow removal in this case, but would forbid it for claims against doctors who take Medicaid, farmers who take crop subsidies, or university researchers who get NIH grants. To me, there is no way that you can allow removal under these circumstances and not allow it in those circumstances, which I think is something that Martin, that Baker, and any number of other cases say is not possible. Finally, I want to address something my friend said about what brings the parties to federal court. What brings the parties to federal court today is not the button that allows a patient to access their medical records. Nobody has a problem with that. The plaintiffs are not complaining about being able to access their records. What brings them to court, and what the complaints allege, is what the defendants did with the information that someone was clicking on those buttons, what the defendants did with the information that patients were entering into the websites when they were interacting with them, when they searched a health condition, when they visited certain web pages. That was being linked to their Facebook accounts, for example, so that advertisements could be targeted to them. It's that privacy violation, which is a commercial activity that the defendants carry on for their own benefit, that is at issue here.
Speaking of that, the complaint alleges that the medical providers here violated HIPAA. Does that mean that the cases turn on a federal defense, a federal issue? That's one of the factors we have to look at.
It does not mean that, and there are a few reasons. So first of all, I think Mesa nicely sums up the two ways in which something can be a federal defense for 1442 purposes. One way is if it supplies a federal immunity, and obviously they're not arguing that HIPAA provides a federal immunity. The other way is if the substantive claim is based on a federal law duty, and the defendant argues that there is no such duty under the statute. None of these claims arise out of a federal duty. They are all state law claims, either consumer protection claims under state statutes or state tort claims. Now, a state tort claim can take as part of what informs the standard of care a federal statute. And I think if you look at the complaints, they allege violations both of the HIPAA standards, but also of industry standards and of the patient's own expectations of privacy. Nothing will ultimately turn on whether HIPAA imposes a particular requirement. It will be a question of state law.
Counsel, on page 35 of the appellant's brief, there's an assertion that BJC Health, of course not binding on us, did not analyze the particular claims at issue here, and there's been some talk today about the claims and the record. Do you see any distinguishing factors that are outcome determinative for any of the circuits that have weighed in on this?
I don't. I think that the only factor that the defendants had identified in BJC Health was the question of whether the allegations centered on the plaintiff's interactions with the portal as opposed to the rest of the website. And as our 28J letter we filed last week shows, the Eighth Circuit has now confirmed that that makes no difference. So they've now heard that argument and found that it makes no distinction. And I think that what I understood the defendants to be saying about those other cases is that they did not analyze in their decisions the various federal tips and tricks that they cite or guidelines that they cite. But I think they didn't analyze them because they make no difference. They just can't move the needle in a case like this, where there is no indication that you have anything beyond simple compliance with regulations. And Judge Lee, as you pointed out, Martin is really the gold standard on that, and it shows that even where a regulation is very important to, it can be a life or death situation as it was in Martin, because these were regulations that covered dealing with COVID in nursing homes. And even when reimbursement from Medicare and Medicaid is on the line, that is not enough to turn private entities' private conduct into official conduct. If there are no further questions, thank you very much.
Thank you. Mr. Carney?
Thank you, Your Honors. The one thing I can say just from Sarah Bush Lincoln, there is a negligence per se claim in there based on HIPAA, where the duty does arise from HIPAA. To Your Honor's question, It's paragraph 159, App 649, pursuant to the laws set forth herein, including HIPAA and the HIPAA privacy rule and security rule. That is the basis for the violation. The one thing I want to say, and obviously, we're not treading new ground here by any means with BJC and LCMC and more. I'm not trying to run away from that in any way. I do think the flaw that I see most in those opinions, and we see most in those opinions, is the idea that there was high-tech and there was a voluntary incentive program under high-tech, and then that was kind of the end of the analysis. It was like everything that came after that isn't analyzed in the opinion, and that's where I think going back to
So, counsel, are you saying they're factually different, or are you asking us to depart from them?
I don't think they're factually different, Your Honor. I'm not sure the court has to depart from them to reach a different result. You can just say, we're going to analyze the record. We're going to analyze what happened from 2011 forward. We're not going to stop with high-tech. We're going to look at the entire factual picture of collaboration and assistance and under Watson. And to us, that adds up to a different result. Again, I don't mean to go back to, kind of this whole notion, but that's where I think they got him wrong. And looking at the 2011-2015 strategic plan, where this all starts, only 7% of Americans have used a website to access their health information online. The single biggest lever to individual empowerment is access to data. And this is App 423, App 427. The Federal Health IT Task Force has recognized individual access to data as a primary objective. And this is where we did what the federal government asked us to do. And that's where I think 28 U.S.C. 1442A1 is a we have your back statute. You do something for us. Collect customs in 1815. Enforce the revenue laws in South Carolina in 1833. You do something for us. And obviously times have changed. We have your back. We'll give you a federal forum when what you did for us is challenged under state law. And that's what I think we have here.
All right. Thank you.
Thank you, Your Honors.
We will take the case under advisement. Calling now case number 2, appeal number 233200, Yas Venture Holdings versus Mocha Financial. All right. You'll have to help me. I'm going to call Mr. Zamuda. Am I pronouncing that correctly?
Yes, you are, Your Honor. Thank you. Good morning. May it please the court, counsel. This case is about more than $600,000 of software development work in exchange for a 15% equity interest in Mocha Financial. The primary question for this court is whether the asserted claims to obtain such 15% interest were wrongly dismissed. The standard of review, as the court is aware, under 12b-6 is de novo. A claim should not be dismissed if it is facially plausible, meaning it is supported by factual content, allowing the court to reasonably infer the defendant is liable for the alleged wrong. Dismissal must be rejected even if proof of facts is improbable and recovery is very remote and unlikely. We have asserted a number of claims here, but underlying all of those claims is the question, what did the Mocha defendants do? They made a deal, then they attempted to change that deal, which is the ruse, as we say. Then they said, we have no deal, which completed their scheme. Yas Venture performed pursuant to the agreement it had. If it had not performed, clearly the Mocha defendants would be here rightfully arguing Yash Venture gave nothing for a 15% interest.
So I take it then, I just want to make sure that
Yes.
I'm reading the record correctly, that that the defendants accepted the services that were provided by Yash Venture Holdings. Is that correct?
That is correct, Your Honor. No question of fact whatsoever about that.
And how does your client value those services? You say it's more than $600,000. What does that mean?
Basically, this was a project by which resources were used to create this software. Some overseas, I believe, some in this country, but people actually configuring the software. And that became the platform for the whole business model for Mocha Venture.
So the $600,000, the salaries and the costs that your client incurred in providing the services? I'm just trying to understand what the $600,000
That's correct. The cost of those resources to develop that software. Thank you. For pleading purposes, with respect to the breach of contract claim that we've asserted, Yash Venture alleged all that was required being an offer, an acceptance, and consideration. The district court and the defendants point to documents unilaterally prepared by the defendants after November 18, 2018, when the oral agreement was reached, to support the assertion the parties had no agreement at all. However, that contention is wrong, as the oral promise and acceptance were not conditioned on the papering of the deal. The November 18, 2018 communication, during which the contract terms were agreed, also is the basis for other factual claims, some in the alternative that were asserted in the third amended complaint.
Can we back up to
Yes.
where you began? So we need offer, acceptance, and then offer. The parties have to agree on a material term.
Yes.
So I take it your position. Well, what's your position? Is the non-dilution? Okay, 15% equity, non-diluted.
Yes.
Is non-diluted a material term of the agreement that your client alleges was reached?
It is, Your Honor, and that is because 15% has to mean something, correct? So what does that mean? The 15% was before initial capitalization, such that funding would continue in the future, but before initial capitalization, or at the time of initial capitalization, that 15% vis-a-vis the interest of others, including the defendants Aurora and Burns, was not to be diluted.
Okay, so if the non-dilution is a material term, how do we make sure we're meeting the Illinois standard that the pleading has to be more than a conclusory statement, but actual words or acts or conduct, just for breach of contract? Because say we go with you that the gentleman's name who was acting on behalf of Behetti, Navarrete.
Yes.
Let's go with your allegation that it was the party's shared understanding
Yes.
that 15% was going to be diluted. We're at the motion to dismiss stage, so say we go with you. How is the shared understanding more than a conclusory allegation of a meeting of the minds? Where do we have words or acts or conduct alleged?
Well, I think that becomes the issue of the pleading standard, Your Honor, and we've cited cases in our brief that we think the court held, the district court that is, held my client to a more fact-based state court pleading standard than a federal court pleading standard. So, did we have to say with such specificity that on such and such a date, one of the defendants, Aurora, Burns, whoever, said with specificity this? I don't think that level of specificity is required for pleading purposes. Certainly not at this stage.
Counsel,
Yes.
I don't hear you arguing that there was a definitive agreement for 15%, and we're here arguing what 15% means. You're saying that in your complaint, the offer was accepted upon the understanding that, Body, if I'm pronouncing that correctly, interest would not be diluted.
Yes.
But you never make any allegations about what the appellee's understanding was.
Well, that's the intent of paragraph 8 of the complaint. It's the party's understanding. It's not Mr. Navuluri's understanding. It's the party's understanding. And that's really the intent of paragraph 8 of the complaint, which is the basis for that claim.
Can you, kind of following up on the questions that my colleagues asked, what was the basis for Mr. Navaliri's understanding that the 15% was for non-dilutable interest?
I'm sorry, the conversation that he had with Mr. Aurora, and that the 15% interest would not be diluted before or during the initial round of capitalization, which perhaps is outside the scope of the record, but during the time that my client was performing services, I don't think that happened. In other words, I don't think it was initially capitalized with that initial capitalization plan.
So are you saying that there were further conversations with regard to whether or not the 15% interest is dilutable?
No, I'm not saying that, but obviously the defendants issued certain papers beyond November 18, being the term sheet, being the capitalization table, being the MOU, and so that initial conversation is what created the agreement on November 18, 2018. That did not change in terms of the parties' understanding. What changed is them saying, okay, now we're going to change the deal. That's what changed.
So the MOU states that basically it's it's kind of non-binding, that these are kind of what we're kind of thinking about. When your client received the MOU, did your client ever attempt to call the defendant and say, hey, look, it is binding, all this language in the MOU, because the MOU was received after this phone conversation, right?
Yes.
Was there ever an objection made saying, I don't understand why you say it's not binding, because, we had this agreement?
Well, I know there were conversations. What specifically was stated, I don't think that's in the record. But again, there certainly were conversations that at some point there was documentation that was sent by the defendants to my client misrepresenting the deal, saying, sign this, and my client refused. He said, that's not the deal. So ultimately, did that happen? Yes. At what point before that did it happen? I don't think the record.
When your client received that MOU that Judge Lee was asking about on
Yes.
March 1, I believe it was, December 2018, and the MOU does misrepresent what your client understood to be the agreement. Why did your client begin working on March 1 by launching Yas Venture Holdings to begin to perform the development work?
Well, what the MOU stated correctly is the plan, and Party B, being my client, having a 15% equity interest. So, that part of it was correct. My client was operating under the initial agreement of November 18, 2018, and rightfully began performing that work and providing the consideration that it agreed to provide. If it had not done that again, we would be here with a different argument that we didn't perform, and therefore we were in breach of the contract. So I don't know if I've answered the court's question, but again, it all stems from the November 18, 2018 contract.
So, I'm sorry, go ahead.
Then when your client 6 days later gets the term sheet, which also seems to not reflect the party's initial agreement, your client continues to work. Why?
Because of the initial contract, November 18, 2018. In other words, my client said, in my mind, we have a deal, and I'm going to honor that deal, and I'm going to perform work. In fact, that continued for a long period of time before the defendant said, okay, stop work. And so, again, my client, believing it had a deal, continued to perform that work.
So I take it that, going back to what Judge Kohler asked you, that your theory is that your client and the defendant did have an agreement on 15%, but there's just, at least on the breach of contract claim, there's just a disagreement as to what the 15% meant at this point as part of the litigation.
Whether, when, and under what circumstances that 15% was to be diluted, I think is a question of fact. I think the defendants have a viewpoint that differs from the viewpoint of my client. I think that's true. But during the course of that November 18, 2018 conversation, my client was clear. we're receiving a 15% interest in exchange for this value of software development work. And it's not, that 15% is not going to be diluted before it's issued, before initial capitalization. That was the deal.
And is there any allegation your client said that on that initial conversation that you said created the contract?
I'm sorry, I didn't hear the question.
You just laid out a bunch of facts about
Yes.
the non-dilutable interest.
Yes.
Is there any allegation in the complaint that your client said that as part of that initial oral contract?
Well, again, I point to paragraph 8, Your Honor, and the understanding that's intended by paragraph 8 of the complaint is the party's understanding. Now, did that change? Was that initially the intent of the defendants, or was it not initially the intent of the defendants? There are pleading and allegations about that in the other counts of the complaint. So, again, I think the primary fundamental issue here is at the motion to dismiss stage, was this appropriate action by the district court? And we certainly claim that it was not.
So, Mr. Sumida, with regard to the fraud claims, right? Other than just your kind of allegation that at the time of the conversation, defendants were intending to somehow dupe your client, are there any other facts upon which we can infer that the defendants actually, that's what they were intending to do at the time?
Well, and we've cited cases in our brief, Your Honor, that subsequent facts can indicate that a prior statement was false. And so if we look at the papering, unilateral papering of the quote-unquote deal by the defendants after the fact, we have the MOU, we have the term sheet, we have the cap table. Those things all become different from November 18, 2018 in that communication.
And is your fraud claim based upon a theory that the defendants should have made it clear to you their understanding that the interest was in fact dilutable?
Yeah, that they never intended to issue that 15% interest before it was diluted. That's part of the allegation of the fraud claims. So yes, and I'm not clear if I'm using my rebuttal time.
You are.
So at this point in time, unless there are other questions, I'll save my remaining time for rebuttal.
Okay, thank you. Mr. Kidd.
May it please the court. We're here, the plaintiff is essentially on their 4th complaint here. This is the 3rd amended complaint. The 1st amended complaint was also dismissed for failure to state a claim. The crux of the case, I think, is whether or not this alleged conversation between Raj Arora and Bala Navaluri, what happened in that conversation on November 18, 2018. And we essentially, the plaintiff's pleading in that regard is basically limited to 2 sentences. One sentence says that Raj Arora offered a 15% interest in MoCA for $600,000 worth of software development work. The next sentence is all devoted to Mr. Navaluri, who is representing Mr. Behetti. And that is that Navaluri accepted the offer on the understanding that that 15% was non-dilutable. Mr. Navaluri's subjective understanding, what he thought, is really not controlling.
That's certainly your argument, which I understand. But one way to read this sentence, and it's not an unreasonable way, is that it is referring to the parties' shared understanding. And indeed, we're at the motion to dismiss stage, where we do need to draw reasonable facts and inferences in Mr. Behetti's favor as the plaintiff. So, okay, assuming we don't go with you, that this is Mr. Navaluri's subjective understanding, but this sentence is about the parties' shared understanding, what more does Mr. Yash need to say in this complaint, at least for a standard breach of contract claim,
Okay.
Without holding him to a heightened pleading standard.
The fact of the matter is, it does not contain nearly enough of the material terms that you'd have to have for that contract. It doesn't tell us what form that 15% is going to take. Is this common stock? Is this preferred stock? Is it some sort of convertible interest? It doesn't tell us when it's going to issue. It doesn't tell us, and this is all pointed out really in Judge Darrow's order. You could not essentially perform that contract based upon simply what was contained within that portion of the pleading. And there's no indication that they discussed any of that in the pleading. So we don't know what those other material terms would be. And you can't ignore what happens after that. And that is the memorandum of understanding that was issued.
Well, before we move on to that, our law, and Illinois law, says you can tell what's material if it becomes a bone of contention between the parties later. And here, what's in contention is this idea of non-dilutable interest. So let's assume that's the material issue here. How is that not in paragraph 8?
Because, again, you have to look and see what each of those sentences was addressing. The first sentence addresses what Mr. Aurora addressed or offered to Balanavaluri. The second sentence gives you what Balanavaluri did, and it is restricted to him. It would be a very simple matter if the parties had agreed that it was going to be non-dilutable to plead that. And they don't plead any facts which support that. What they plead is that Balanavaluri thought it was, at least according to that pleading.
But you haven't accepted what I told you in my question. Let's assume we don't go with you on that. If we say this sentence here talks about the parties' shared understanding, what more does he need to plead? And then your answer to me is we need some more who, what, when, why, where. That certainly sounds like a heightened pleading requirement.
I'm not saying it's a heightened pleading standard, but they do have to at least put in the material terms. And you can just look at this and say the material terms for a deal like this is going to include the form of the interest, when it's going to issue, what they're going to have to do so. And that's without even thinking about the memorandum of understanding.
So, Mr. Kidd, what concerns me about that argument is that in the end, the parties obviously believed they had some agreement, right? Because the plaintiffs performed and your client accepted the services. So there's some agreement there. I don't think you were saying that your client thought that the service is going to be performed for free. And so if that's the case, why isn't this a case like any typical breach of contract case where the parties agreed to a contract, but there's a dispute as to what the terms were? That is a run-of-the-mill breach of contract case, as Judge Kohler was noting. Why isn't that what we have here, as opposed to a case where there was no agreement to begin with? Because if that's the case, then why do you think what's the explanation for the plaintiff providing the services and your client accepting them?
Well, I think my client, it's not in the record as to what the parties were thinking at the time.
At the time of what?
At the time that those services were provided.
Okay.
And I think my client expected to pay for them, get a bill and pay for them. And in fact, if you look at the subsequent,
So despite all of these conversations beforehand about not paying for it and just giving the plaintiffs an interest in the business, now you're saying that in fact your clients actually were going to pay for it in cash.
I think by the time they got to the services being performed, yes, sir, because when the term sheet was issued on March 7, and in the term sheet it provided for not software development work for their interest, but an investment of $600,000 in cash, which would have essentially provided the the capital to pay for the work that was done.
So what you're saying is that your clients don't owe the plaintiff an interest in the company, but you're conceding that your client, at a minimum, owes them money for the services they gave.
I would suggest that they probably were owed money for the services, but in this, it would be more on the nature of an unjust enrichment claim. So we did all this work, we didn't get paid, but the plaintiff is not wanting to get paid. They could have, in the alternative, asked for compensation, equitable relief with regard to the unjust enrichment claim, but they don't want that.
I understand. I guess my point is that the parties' conduct after the conversation, what the parties did, seems to, at least plausibly, maybe not persuasively, but that's not the standard now, plausibly indicate that the parties had some sort of agreement that leading up to the performance of that contract.
I think they had, they were maybe starting work and a little before the completion of the planning, but you have, like with a lot of startups, what you had was sort of a very fluid situation. You had this conversation supposedly that occurred. Then you have the memorandum of understanding, which is not consistent with that what they say that conversation was. But it does say, and it indicates that this is forming the basis for discussions concerning equity, roles, etc., and that some definitive agreement was contemplated. And then you have the term sheet, which, I mean, that was 7 days after they supposedly began work. And it says $600,000 cash is the way you get your 15%, and which was never contributed, obviously. And then there is the cap table, which comes out about a month later, and in that it reflects that the interest for Bahetti's interest, Yash, was going to be 7.5%. This was a fluid situation that they had never resolved. They began work knowing that they did not have a deal, they did not have a contract, and it's not up to the court to make the contract for them. If they may have simply been, it may be benign, but it may also be that they said, okay, we're going to get in here and we're going to do the work, and that's going to better our bargaining position with regard to where we are in this company. We don't know that. But what we do know is that the pleading itself doesn't say that either one of those parties made that offer to the other one in November and was accepted by the other party. I submit to you cannot read that pleading and really parse those two sentences and arrive at that conclusion. Likewise, therefore, I say that they have not, I submit that they have not adequately pled a breach of contract action that is plausible on its face. With regard to the promissory estoppel claim, again, they have to show that somebody made that promise to them. And they didn't really plead that Raj Arora or John Burns actually promised them a 15% non-dilutable interest. And that is what they're trying to get specific performance of. I know that you can look at other facts that are pled to conclude that that promise was made. But if you look at the other facts here, they don't support that that promise was made. And that really is one of the important reasons that you look at the memorandum of understanding, because it says this is all fluid. This is we're talking about forming a card processor. We've got we're going to have future discussions about equity, etc., and roles. So the other facts don't support the implication that the promise was made. In fact, they support that that promise was not made, that it was going to be a 15% non-dilutable interest, because in neither the memorandum of understanding nor the term sheet is it reflected that they were non-dilutable. So I submit to you that the court properly dismissed the promissory estoppel claim. They also claim breach of fiduciary duty by Mr. Aurora and Mr. Burns. And really, in order for there to be a breach of fiduciary duty, first they have to establish that there is a fiduciary duty. The only thing that they plead here as establishing the existence of a fiduciary duty is that they refer to Burns and Aurora as promoters, that they were promoters of this stock. The fact of the matter is, when you look at the three of them there, if Burns and Aurora were promoters, then Mr. Behetti was too, because he was an active participant in this at the very first stages. But they don't plead any underlying facts which show the basis for a fiduciary duty. The pre-existing relationship that you normally have for the trust and confidence to arise, where one trusts the other, they don't plead any of that. They base it solely on this claim of promoters. And I submit to you that it's clear that that does not establish a fiduciary duty, and the court properly dismissed those claims. I can't remember which amended complaint, they added an Exchange Act claim. The Exchange Act would require a purchase or sale of a security, which has not occurred. Admittedly, an enforceable contract for the purchase or sale of a security can supply that. That goes back to the contract argument, and that there was never a contract for the purchase or sale of a security. They also had to plead and establish scienter. And, you know, that's I'm not a securities lawyer as such, but my understanding, it requires essentially the knowledge and intent of the defendant to mislead and manipulate. And they really don't have any evidence of that, and they don't have any pleading of it. If anything, it appears that they're not hiding from the plaintiff anything with regard to their concept that they're going to change the ownership interests over time. Look at the memorandum of understanding or the term sheet, and they're both disclosing, hey, this is what we're planning on doing with regard to those ownership interests. So this intent is certainly not reflected. And the Exchange Act claim would be subject to 9B. Oh, I'm getting close to my time, not already there.
You are there.
I'm sorry, I didn't notice. Thank you, Your Honor.
Thank you. Mr. Zamuda, we'll give you 2 minutes.
Thank you. With respect to the breach of contract issue, counsel was stating those terms are not clear. They were clear, and what paragraph 8 very clearly alleges is an offer of acceptance. And Exhibit D to the complaint is a June 10, 2019 email from Mr. Burns to Mr. Behetti and others, in which he discusses a number of things. But one of those things is, and we don't agree with the date obviously, but he said we had originally presented essentially a plan for 40% for this new company to be formed, 15% for Mr. Burns, 15% for Mr. Aurora, and 15% for key executives, and 15% to Yash, at a valuation of $4 million. That was the initial capitalization based upon which my client was offered the 15% interest and accepted that. Then he says, however, after talking with counsel, the fundamental problem with the all-common equity proposal. So it was clear to them that it was common stock. To say otherwise is simply contrary to the record. So we think that contract was clear. It was formed in November 18. Everything that followed was the ruse to dilute or somehow change that interest before it was issued. Council also discussed the issue of the fiduciary duty, and it is accurate to state that we alleged that Mr. Burns and Mr. Aurora are either promoters, directors, or officers of the company. We cited very specifically Delaware law. MOCA is a Delaware corporation. Judge Darrow, in her opinion, seemed to question why we were citing Delaware law, and that's because the entity is a Delaware corporation. But very clearly that case authority states that promoters, officers, and directors are fiduciaries. So, and we also allege that the agreement reached in November was the subscription agreement, which both of those terms, promoter and subscription agreement, are terms of art that the court can, understand. With respect, finally, to the Exchange Act claim, counsel was discussing Sienter. We cited in our brief the Carpenters Pension Trust Fund case, which says a contrary statement made after the initial false statement is made can be evidence of the initial false statement and should not be discounted as fraud by hindsight. And what we're saying is, essentially, if you put together the papering of the deal, as the defendants would like to call it after the fact, including an interest, and it's not clear how much, but of certain executives of a bank and Visa, which were disguised in the interests of Mr. Burns and Aurora, and not separately stated on a cap table. You put all of those facts and the totality of the circumstances together, and that can create enough to provide Sienter. I'm sorry, Your Honor, I think has a question.
No, you're at time.
I'm sorry, thank you.
Okay, thank you. We'll take this case under advisement, and we are going to call case number 3, Appeal 23-1718, Cisco Indianapolis LLC versus Teamsters Local 135. Okay, we welcome to the podium Mr. Vlink. Am I pronouncing that correctly? Yes. Okay.
May it please the court, counsel. My name is David Flink, and I'm appearing on behalf of the appellant in this case, Teamsters, Local 135. Local 135 and the appellee, Cisco Indianapolis, have had a long-standing dispute over whether their collective bargaining agreement requires Cisco to pay Local 135's members and the employees it represents a supplemental early retirement benefit of $500 a month if they retire between the ages of 55 and 65 with 20 years of service. There's a long history, but this case just relates to whether there's a current grievance over Cisco's failure to pay that benefit is arbitrable. The collective bargaining agreement between Cisco and Local 135 contains an arbitration clause that requires arbitration of any controversy, complaint, or dispute arising as to the interpretation or application of or the compliance with any provision of this agreement. Local 135's grievance in this case, protesting Cisco's failure to pay the supplemental early retirement benefit that was negotiated and agreed upon during collective bargaining negotiations in 2013, is arbitrable under the plain language of the arbitration clause and controlling Supreme Court and Seventh Circuit precedent regarding the arbitrability of disputes arising under collective bargaining agreements.
Seems to me we have cases going in two different directions. You were absolutely right that Mr. Smith's grievance cites Article 18 of the collective bargaining agreement. So a court deciding deciding the matter of arbitration, whether it can be arbitrated, could simply look at that and say it cites the CBA, that's what we're going to decide whether it goes or not. Seems to me we also have courts that actually go to the substance of the claim and decide whether that dictates the arbitration question. Why is your preferred method, when we have cases going both ways, the superior one?
Because Supreme Court law, going back to the Steelworkers Trilogy in 1960, is really the foundation Supreme Court cases. And specifically, we're talking about American Manufacturing and Warrior and Gulf Navigation, those two cases from the trilogy. The court specifically says that the arbitrability determination has to be made without regard to the merits of the grievance. And the courts have no business in the seventh, this court has said this as well, is the court has no business in considering whether there's equity in a claim or determining whether there is language in the agreement supporting the grievance. So it would be improper in our view to go to the merits to say, okay, does the contract support the grievance or not? We certainly think it does, and we've laid out with specificity numerous contract provisions that we think support our grievance. And I would also like to note the grievance itself, it does cite Article 18. If you look at it as well, it also says, and all others that may apply. So we have Article 18, and Article 18, if you read it, it just says that the employees are eligible to enroll in the Cisco pension plan.
But counsel, is the pension plan itself part of the CBA, or is it a separate agreement?
No, it is not, and that is, I think, is actually an important point, and thank you for raising that. That is not what we are saying. We are not arguing that the pension plan is incorporated into the contract. That's the Nabisco case. That's the case that's relied on most forcefully by Cisco. And in that case, the union and the grievance did claim a benefit under the terms of the pension plan document. And that's why that case is distinguishable, and it is different than our case. We are arguing that the supplemental early retirement benefit is protected by the collective bargaining agreement, regardless of what the Cisco pension plan document may say about it.
So, and just to clarify, what you're arguing is that despite the fact that the supplemental retirement benefits, the right to it, are not explicitly mentioned in the CBA, that if we look at the history of how the parties developed, the parties had agreed that the 2018 CBA would include a requirement that the employees receive an SCRB, right?
Absolutely.
And is that where the argument, so what you're arguing is that the right doesn't flow from the pension plan, but from this agreement that the parties had that would be part of the 2018 CBA that didn't actually make it explicitly into the CBA.
That's correct, Your Honor. And the one thing I would correct you on is the agreement actually happened in 2013,
right.
The 2013 contract.
And is that why the absence of a zipper clause matters?
Absolutely. It's very important that our contract doesn't have a zipper clause or what a commercial contract might refer to as an integration clause, where it would say our contract is limited to the express words written herein. In fact, we have the very opposite of that. It's called a maintenance of standards clause. We have that in our contract. And one of our arguments, and there are many, is that we had an agreement in 2013 that our members would receive the supplemental early retirement benefit, and the eligibility requirements were very clear. The amount of it was very clear. When the first employee retired, that they didn't get it, a grievance was filed, and that went to a joint grievance committee panel, which for purposes of Section 301 is no different than an arbitration, because that panel had the authority to render final and binding determinations. And that panel unanimously sustained the union's grievance, in effect saying, Cisco, you're incorrect, you violated the contract, the union and its members are entitled to this benefit, okay? And that was under the 2013 contract. Nothing changed with regard to that in the 2018 contract. And the 2018 contract has a maintenance of standards provision that says, those conditions of employment that aren't expressly stated herein.
But Mr.
have
Blink,
to
what are
continue.
we to do with Cisco's argument that while the parties were negotiating the 2018 agreement, that the union requested that the right to a supplemental retirement benefit be expressly included in the CBA, and Cisco said, we're not going to do it.
Thank you, and that's also a very important part that I think the district court got incorrect. What the evidence on that is actually disputed, but it really goes to the merits versus the arbitration clause, and this court stated that in the Trimus case. When we're talking about that kind of evidence for purposes of arbitrability, the evidence has to go to the arbitration clause itself, and there is no...
But it does, doesn't it? Because if the obligation arises out of the pension plan, then we're in Nabisco land, and that sounds kind of nice. But but if our dispute arises out of a, let's call it a unwritten term that the parties agreed to as part of the CBA, then it arises out of the CBA. So it seems to me that that does relate to arbitrability.
Okay, even if it does, it's disputed as to the nature of the discussions during the 2018 negotiations, and that would have to be determined by an arbitrator. Cisco says that the union proposed that we're going to have the served now, and we want it written in the contract. We have evidence, an affidavit from the union's negotiator that says, no, what actually happened is we just simply proposed to clarify the contract of an agreement that was already reached. And then in response, Cisco didn't reject that proposal. It said, and it's important to know, the earlier litigation was still ongoing at this time. And Cisco said, we don't want to negotiate over something that's currently in litigation, but we will follow whatever the court's decision is. And the union prevailed in that litigation. So from our perspective, that means there was an agreement that we would continue to have the supplemental early retirement benefit. And I see that my time is expiring. I'd like to reserve the remainder of my time for rebuttal. Thank you.
You will. And Mr. Carter.
Thank you, Your Honor. May it please the court, my name is Mark Carter. I represent Cisco Indianapolis. We're here to try to help the court decide whether or not the parties agreed to arbitrate pension benefits. Now, you've just heard counsel for the union say, but they're not pension benefits, they're a part of the contract. Let's look at what the Seventh Circuit says about trying to make a determination as to whether or not there is substantive arbitrability. And that is plainly and firmly defined in the Nabisco case that's been referenced. And we believe strongly that this case is nearly on all fours, factually.
But in Nabisco, the union didn't make the argument that there was a separate agreement apart from the pension plan that would give them the right. And here, that is what the union is arguing.
Absolutely correct, Your Honor. The problem is there is not an agreement. There's no evidence.
Well, I guess that kind of goes to my next question, which is, where you have a case like this, where the determination of arbitrability, in other words, whether or not the CBA had an agreement between the parties as to the supplemental retirement benefits, because if that's part of the CBA, then it's arbitrable. If it's not, then it's not. And there is kind of an overlap between that issue and the merits issue, obviously. Is that factual determination or determination something that the district court should make, or is that something that the arbitrator should make?
It's one that the district court should make, because under the Steelworkers Trilogy, the court was very clear that this is a judicial question, not necessarily an arbitrator's determination. It's a judicial question always as to whether or not there is substantive arbitrability.
But what if the district court's determination, in effect, decides the merits of the dispute?
If the district court needs to determine the merits of the dispute by referring to the collective bargaining agreement to determine whether the party is entitled to win the arbitration, then it's not permitted. But here, the merits of the dispute are actually defined under the plan itself. The CERB is expressed within the Cisco pension plan. Section 10 of the pension
I guess let's take it separate and apart from the CERB and the pension plan. Say that the union is arguing that separately the employer agreed to provide every employee with a car, okay? And your client's position is that did not happen, right? That's not part of the CBA. And so the union says, well, we think it is part of the CBA, and so that dispute has to be arbitrated. And your client says, no, that's not going to be arbitrated because that clause, that agreement is not part of, there was no such agreement that's part of the CBA. And so then the initial question of whether or not something is part of the CBA is the same question as the merits. And so in a situation like that, what is a district court to do? Does the district court still have to determine arbitrability by looking at it so long, even if it has to decide some merits issues along the way?
Yes. Nabisco makes it clear that not only is the court the appropriate determinator of that issue, but the court outlines what the court should be looking at. The court should be looking, in this kind of a case, if I may return it back to the instant case, the court should be looking at whether or not the pension plan was created in the collective bargaining agreement or if it's independent of the collective bargaining agreement. In Nabisco, the plan was pre-existing, and it covered thousands of employees nationwide. It did so, and that was relevant because if the pension plan is separate and apart from the collective bargaining agreement and the parties didn't negotiate the terms of the pension plan, then that doesn't make the issue arbitrable. Exactly the same here. The pension plan was created at least 1973, decades before the dispute arose, back when I was playing Little League, and I've been through a few games, and they're totally independent from one another. The court instructs us to look to the bargaining history between the parties. Why? Because the court wants to know if the terms that are sought to be arbitrated were proposed and either accepted or rejected in bargaining.
What's your best evidence of the bargaining history here?
The best evidence of the bargaining history
Is what
here
is what
is
Cisco
as
says
the
it is.
court referred to Scott Richardson's deposition that includes in the record the actual bargaining proposals made by the union, which can be found at docket 24-1, pages 1 to 18.
I'm familiar with it.
bargaining-
Why doesn't his declaration actually point to a dispute between the parties? Because his declaration basically says, the Cisco is not going to negotiate the inclusion of CERB in the CBA because, it's in litigation.
Your Honor, Mr. Richardson testified as well that Cisco would not bargain over pension benefits.
That's right. So we have two actually different things. We have his testimony saying our position writ large is no pension benefits will ever be in the CBA. But we also have these notes in the record, okay? The bargaining notes and the handwritten note saying another reason, a contrary reason perhaps, is that it wasn't going to be included because it's in litigation. They're going to wait. They're going to be bound by what the district court decides.
It's very interesting. The bargaining notes you're referring to are from one of the negotiators in the 2013 contract, not the 2018 contract.
But it still hadn't been decided at the time they were negotiating the 2018 contract, which is why it was still relevant. What was happening with the 2013 decision was relevant during the 2018 negotiations. So why isn't, my question is, why is that not a dispute about what the bargaining history shows?
They're not, Your Honor, they're not in dispute. The 2013 litigation is whether or not Cisco complied with a determination of a joint panel. It was not about whether or not the CERB was in the contract. In fact, if you look at the decision of the joint committee, they don't find that there was a collective bargaining agreement. And that's located at docket 19-2, page 28 of 28. What the panel found was that at the time of our ratification vote in March, we were told that all bargaining unit employees would receive $500 a month above our normal pension. And then the company said there was more criteria. That's what the joint panel found. Well, if Cisco wasn't paying the requisite amount of pension benefits, then what is the objective of the grievance that's at issue today? It's to get more pension benefits. And pension benefits are only provided by the Cisco plan, and they're only provided by the Cisco plan under the constraints of that plan, and that's what it says in the contract as well. And the constraints of the plan are you can only get more pension benefits in a dispute if you bring a claim under the plan. That's what you need to do in order to get to an ERISA action. This is not a matter that the parties agreed to arbitrate because it's not in the contract. And Nabisco says you need to look for whether or not there is a lack of pension terms in the CBA. The review of either the 2013 or the 2018 contracts, it's self-evident. There are no pension terms. The only right in the contract is to eligibility to enroll. It was top of mind to Mr. Richardson negotiating the 2018 contract that there be no benefits, pension benefits in the contract. And that is why there's no eligibility, and that's why under Nabisco, the decision of the district court was inevitable. I'll yield my time unless there's any more questions. I was told once by a circuit court, Mr. Carter, when we stop asking you questions, stop talking.
Thank you, Mr. Carter.
Thank you, Your Honor.
Mr. Vlink. We'll give you 2 minutes.
Thank you, Your Honor. One thing I'd like to point out, just as a matter of the record, Your Honor asked about the notes, and Mr. Carter said that those notes were from the 2013 negotiations. They're actually not. They're from the 2018 negotiations, and I'm looking at Appellant's Appendix 230. Next to the union's proposal, there's a handwritten note from Cisco that says not negotiating something in litigation bound by the decision. So those were the notes that I thought Your Honor was referring to. And so that really highlights what was talked about, discussed during the bargaining history in 2018 that Cisco relies on. Secondly, counsel said, you know, if you look at Nabisco says if there's a lack of pension terms in the CBA, then that should indicate that the grievance should not be arbitrable. I don't believe that's correct. I don't believe that's really what Nabisco is meaning to say, and I think the court's two subsequent cases in Exelon and Carl Schmidt Unisha are really instructive on that point. There was those were both benefits grievances where the employer was arguing this is not arbitrable, it's under the plan. The union was pointing to language in the contract that it argued guaranteed contractually those benefits for its members. There's nothing in those cases that says that language has to be specific to the benefits. It doesn't say that, and that would actually be an incorrect holding, again, because American Manufacturing Quote, the Steelworkers Trilogy, says the courts have no business determining whether there is particular language in the written instrument which will support the claim. And with my last 10 seconds, I would just like to point to this court's decision in IBEW Local 21, and there was no language in that contract whatsoever regarding the subject matter of the dispute. but the court found it arbitrable anyway based on the union's citation to other contractual provisions. Thank you very
Okay,
much.
thank you, Mr. Flink and Mr. Carter. We'll take the case under advisement, and the court will take a brief recess. Morning. Is it Mr. Greco? Yes. Or Greco? Greco. Greco. Welcome you.
Good morning, Your Honor. May it please the court, counsel, and clerk. My name is Michael Greco. I represent the plaintiff appellant Paula Emerson. And as Your Honors know, this is a case appealing the dismissal of a case for Illinois Workers' Compensation Act retaliation. The critical issues in this case that we submit merit reversal are the treatment of the 5-year pendency of the workers' compensation claim, which was pending at the time of Ms. Emerson's dismissal in 2019, as an isolated event that is encapsulated in the year 2014. Of course, treating it in that restrictive fashion as if it began and ended in 2014 would make Ms. Emerson's firing in 2019 appear to be remote by any measure. Certainly the case law is pretty uniform as far as time periods of that scope. In this case, however, the case was pending during that entire time period. A significant wrinkle with that circumstances that Officer Emerson, Ms. Emerson, was on leave from her employment by Sheriff Dart during the entirety of the period of the pendency of the workers' compensation claim from 2014 to her firing in 2019, and even before that for about 1.5 years when she was on paid medical leave or due to a psychological distress event from September of 2012. So there was no interaction between the plaintiff, Officer Emerson, and Sheriff Dart from 2014 until her firing in 2019, excepting the leave, and she had to recertify periodically to continue even on unpaid leave, and the workers' compensation case. We did aver in the amended complaint that the same lawyers that represent Sheriff Dart in all the cases he has in the courts, the Cook County State's Attorney's Office represented the sheriff, and the Cook County Sheriff's Office is Sheriff Dart's agency in defending the workers' compensation case.
Can you help me to understand that allegation a bit?
Yes.
I understood it with regard to the Title VII suit, the idea that the state's attorney's office would be representing the sheriff in defending against the unrelated Title VII lawsuit. And so therefore the folks on the ground in the sheriff's office would know about her litigation history. Can you help me to understand the plausibility of it with the workers' compensation claim? The idea that the Cook County State's Attorney's Office would be talking to the supervisors and decision makers at the sheriff's office about her workers' compensation claim. Are those claims adjudicated or processed through the Cook County Sheriff's Attorney's Office, State's Attorney's Office?
Yes, they are, Your Honor. I personally have never been an assistant state's attorney or a state's attorney, but I know from the experience and that I believe it's the Labor and Employment Division of the Civil Bureau of the State's Attorney's Office represents the Sheriff Dart and the Sheriff's Office on all of their civil litigation, I believe, unless it's privately
In
farmed
workers'
out.
compensation claims?
In workers' compensation
There's
before.
no separate agency, county agency, that processes workers' compensation claims?
There is not, at least not that was utilized in this case, and I've had other cases with the Sheriff's Office. It's always, in my experience, has always been the Civil Bureau of the State's Attorney's Office that represents Sheriff Dart and the Sheriff's Office before the Workers' Compensation Commission. And they might have specialties within that office where certain attorneys do more workers' compensation, certain attorneys do more excessive force.
And let me ask you another question.
Yes,
so Ms. Emerson, Officer Emerson, is sitting at home, and she gets this termination letter in 2019. Surely there's a name on the termination letter. Why doesn't she put that in the complaint and go from there?
That's a judge. She just had no knowledge of what that individual person would know besides being the name that's on the letter. We submitted. The second argument that I have is that there was error in denying pretrial.
But she doesn't even name that person as a defendant unless the only name on the letter termination notice she got is Tom Dart.
I actually don't recall who precisely signed the letter at this moment, but we would still need to establish that that individual, and it was not Tom Dart, would have been familiar with.
So I'm asking, why didn't you
Officer
sue that
Emerson's.
individual as well?
That's, that, we did not have.
Because one of the district court's complaints is you don't really know where you're even going to start about who made the decision to fire you. But there, she's got a lead there. The lead is on the termination notice.
She's got a lead. We needed the pre-motion discovery in order to establish that the person who signed the letter firing Officer Emerson was familiar or conversant with the fact that she had a workers' compensation Workers' Compensation Act claim pending. We submit that there is every reasonable inference to believe that there would be that awareness, again, because there's nothing.
What is that reasonable inference? What makes it just more than possible?
Because there was no other interaction between Officer Emerson and the sheriff's office other than the Workers' Compensation Act claim and the leave, the unpaid administrative or unpaid medical leave that she was on.
Mr. Greco, then, do you have a theory as to why, if in fact it was a workers' compensation claim that motivated the termination, why the sheriff's office waited 5 years before terminating her?
It was not. I don't have a theory other than the fact that they may have been frustrated that they were not able to settle the workers' compensation claim. They might have just wanted her off the books, which I submit would be improper if she's on unpaid medical leave. But there was no. But I don't have a theory beyond that. It's the scarcity of any interaction between the sheriff's office and Sheriff Dart and the plaintiff, apart from the Workers' Compensation Act claim and the medical leave that I submit affords a plausible inference that the person who, the decision makers who decided to fire her in 2019 would have been aware of the workers' compensation case and of the fact that it was pending for some 5 years. If you look at the cases that the district court cited, most of them did involve fairly isolated episodes in workers' compensation. The district court cited a state court case, the Fox versus Adams, and that was a case where 10.5 months elapsed between the employee plaintiff's return to work after workers' compensation and the firing. So in that case, of course, the appellate court of Illinois found that there was no causal connection based on the temporal remoteness. Similarly, in Strong versus Quest Diagnostics, that I believe is a district court case, it may be a Seventh Circuit case, 3.5 years elapsed from the denial of workers' compensation to the firing. All of these cases really that have been cited have fairly short terms in the workers' compensation process, and that makes it much more obvious or clear for the district court and the appellate court to find the temporal remoteness. But with the case pending in this case, I submit that there is at least some inference of the possibility or plausibility of retaliation based on the firing to justify pre-motion discovery. And as the court has noted, it's the district court and this court has noted, the district court does have broad discretion in regulating discovery. We submit that it was error to prevent any type of discovery pre-motion on the basis of the failure to name the individual defendant specifically in this case. So I don't believe that this case is analogous to the McCauley versus City of Chicago case. That was a case, a Monell case as attempted by Mr. McCauley. He also tried to obtain pre-motion discovery from the director of the Illinois Department of Corrections. There was no basis for him to infer that the director himself had an animus. I see my time is up.
Okay,
So,
thank you.
Thank you.
Ms. Harvey.
May it please the court, my name is Colleen Harvey and I'm representing defendants in this case. The district court's order dismissing Emerson's complaint under Rule 12b-6 should be affirmed. In order to survive dismissal of her workers' compensation retaliation claim, Emerson had to plausibly allege that her discharge was causally connected to the exercise of her workers' compensation
Well, let me
rights.
ask you about that. Why isn't it plausible that the sheriff's office got sick of its quote-unquote dead weight? That an employee has been out on disability 7 years and, litigious dead weight at that. She had the temerity to file a Title VII suit as well that had to be appealed. And now, the workers' compensation claim is going into its 5th year, and so the sheriff's office just lets her go. Why isn't that not a reasonable inference based on the allegations in the complaint, particularly given that there was no interaction with her in those 7 years, except for the fact that her workers' compensation claim is pending? And, of course, the fact that she filed a Title VII lawsuit. If we have cases, and we do, and Illinois has cases, that the pendency of a claim is a protected action under the Illinois Workers' Compensation Act. Not just the mere filing, but the pendency, the continued pursuit of the claim. Doesn't that mean the retaliation claim is viable based on the complaint?
Defendants submit that it does not. Emerson has admitted that the only alleged facts are that she filed a workers' compensation case in 2014 and then was terminated in 2019, which is not enough. She is alleging that, that the fact that the workers' compensation claim was still pending in 2019 should create a causal connection. But the workers' compensation claim had been pending since 2014. And Emerson offers no explanation or allegation in her complaint as to why the sheriff's office was okay with her workers' compensation claim. They were okay with her Title VII claim, but yet for 5 years they were okay with her workers' compensation claim. And then all of a sudden they were not okay with it, and Emerson offers no explanation or allegation in her complaint alleging motivation on behalf of the sheriff's office. Instead, for a plausible claim, Emerson would have to plead facts that something changed or that there was a reason that the sheriff's office would have been motivated by the fact that it was still pending in 2019.
Well, for example, I'm looking at the Brooks case where we said that the pendency, the fact that the thing was continuing and had not reached a settlement or agreement or resolution was allowed an inference that the employer was just done, just sick of the matter. And she has alleged she got a notice, with no reason whatsoever. And so the only two facts which she alleged are, I have a claim pending, and I also, by the way, had a Title VII appeal that I made them answer and deal with. So is it quite right to say that she has no facts there from which a reasonable inference can be drawn?
Defendants admit that it is. She has not alleged, and she admits that there were no intervening events from the time that she was on leave since 2012. Now, you bring up the Brooks case. In that case, this court did recognize that the plaintiff did state a claim of retaliation due to a pendant workers' compensation claim because the plaintiff had actually alleged facts, that the case was contentious, that they were working on settling it, that the settlements were not going well, and that the plaintiff in that Brooks case had extensive medical expenses. And those were all facts that the plaintiff pled. Here, Emerson pleads no details as to why she believes the sheriff's office would have been okay with her workers' compensation claim for 5 years and then not okay with it. So defendants believe that the Brooks case can be distinguished.
What concerns me a bit about the position that you espouse is that there is Ms. Emerson would have no idea what prompted the decision, right? Because there hasn't been any contact. Under federal law, you can't get early discovery, right, with regard to these issues. And so what is a plaintiff to do in that situation when all the information, right, is in the hands of the alleged party that's retaliating against her, and she has nothing other than the workers' compensation claim is pending and I'm fired?
That's not enough to establish a workers' compensation retaliation claim. Courts have held that the simple fact that
So let's, hypothetically speaking, okay, completely hypothetical. So let's say that there is an internal memo that the defendants have, where one lawyer, to one of the lawyers that's litigating the workers' comp claim, and the note says, you know what? Don't worry about it. We're going to fire her anyway because we're sick of this. Okay? She has no idea that that's taking place. She has no way to get that information. And so in that situation, what are we to make of that kind of information asymmetry between the parties?
Well, it is a balancing act, I guess, as far as the plaintiff's right to discovery. But in this case, plaintiff has no possible facts that the sheriff's office was motivated by her workers' compensation claim. And
unlike the Brooks case, you're saying.
Yes. And in order to allege a sustainable claim, she needs to allege some facts supporting causation. And otherwise, Twombly requires that causation be shown above a speculative level. And here, plaintiff has only alleged speculation, even as far as has only alleged speculative allegations, even as far as the motivation or not and knowledge of sheriff's office employees.
It's just that arguably the silence, the 7-year silence, the 5-year silence, can be read both ways. It could be they're fine with her being out, they're not bothered at all, so there's nothing at all suspicious about her being let go at year 7 of the disability, year 5 of the workers' comp claim. Or the silence is, it means everything. That means it's the only thing that could possibly have triggered the firing, because it's the only thing that's been going on for 5 to 7 years. And earlier you talked about for her to establish, but we have to be mindful of the stage of the case we're at. This is a motion to dismiss. She's not at summary judgment.
I guess the pleading standards, though, of Twombly still require that she put out a valid, sustainable claim, and she's failed to do that with only her facts of that she engaged in a protected activity, and then she later was terminated. And she has to be able to show more. The whole point of the Rule 12b-6 motion is that defendants don't have to engage in discovery on claims that are not sustainable. And here, defendants maintain that her claim is not sustainable, and she has not presented enough evidence for a workers' compensation retaliation.
So if she had added in her complaint a line that said, and this workers' compensation claim has been going on for 5 years, and they're clearly sick of her, period, would that be enough?
I would submit no, because again, it doesn't offer any motivation as far as, again, it just refers to the 5 years. It wouldn't offer any motivation as to the sheriff's office. I would say under Twombly, she would be required to plead more facts to establish a plausible claim as far as what happened. On that basis, here, Emerson has failed to state a claim of workers' compensation retaliation. She offers no facts establishing causation. Unless the court has any other questions, defendants respectfully ask that the court affirm the district court's order dismissing plaintiff's complaint.
Thank you, Ms. Harvey.
Thank you.
Mr. Greco, we'll give you 2 minutes.
Thank you, Your Honor. May it please the court, the implicit in counsel's argument is that the sheriff's office could inoculate themselves against retaliation claims simply by delaying the resolution of the workers' compensation long enough that they get outside of a safe harbor period for retaliation where it would be deemed plausible. So maybe don't go to hearing or don't settle within 2 or 3 years. If you want to retaliate, wait out the 5 years, and then it's going to be concluded that it's too temporally remote. I submit that this case is analogous to the Brooks case, and precisely because Workers' Compensation Act cases are not generally especially contentious in the way that we might think of them as being, and 5 years of litigation implies some level of contentiousness. Your Honor also referred to the other litigation, the Title VII litigation that was pending between the parties that was concluded in 2018. But as far as the workers' compensation case itself goes, the pendency thereof, we submit, does imply a basis for retaliation that did get under the sheriff's office skin, figuratively speaking.
Counsel, there's some information that you could have pled. The individual on the letter, as Judge Coleman pointed out, you could have looked at whether or not the sheriff's office had any reorganizations, said, hey, there's no other reason here. That's not in your complaint, is it?
It is not in the complaint. Again, I believe I submit under Rule 11, I would have an obligation to have some nexus between the individual signing the termination letter and the workers' compensation case. I don't believe that can be established without pre-motion discovery unless I had access to that individual, which I have not. Thank you.
Thank you. We'll take the case under advisement. And we turn to our final case of the day, appeal number 233256, U.S. versus Rush. All right, Mr. Newton is ready, but all right, go right ahead.
Thank you, Your Honor. Good morning. May it please the court, opposing counsel. My name is Talmadge Newton. I appear today on behalf of Mr. Rush. The appellant, who has never previously been convicted of a felony, was charged and convicted in this case with a single count of possession of a short-barreled rifle, which was not properly registered to him in the National Firearms Registry. The plain text of the National Firearms Act, 26 U.S.C., Section 5861D, categorically burdens the appellant's rights under the Second Amendment. The means and scrutiny analysis set forth in Miller has been set aside by the Supreme Court in New York State Rifle and Pistol Association v. Bruin. Bruin clearly abrogates all means and frameworks and requires fresh examination of the National Firearms Act under Bruin's two-part test. Bruin announced a new two-part test under the Second Amendment for firearms cases. Under the first step, the question is whether the Second Amendment's plain text covers an individual's conduct. In this case, Mr. Rush was a protected person under the Second Amendment. He was not in any way prohibited from owning a firearm prior to this case. The question in hottest contention in this case becomes the question of whether the firearm that he was carrying in this case, is protected, and whether or not the appropriate analysis of that firearm and its characteristics belongs under the first prong of the Bruin analysis or the second prong of the Bruin analysis. I will acknowledge, and I did in the briefs, this court's panel holding in Beavis versus the City of Naperville, where the court seemed to suggest that the proper analysis does occur in the first step. I believe other courts, including a panel in the Ninth Circuit, have held otherwise, that the appropriate analysis is in the second step. I think that is important, and why it is such a key question is because if the analysis of whether it is a covered arm is part of the second step, the burden belongs to the United States to prove that convincingly. In this case, I believe that the district court failed to analyze the Bruin analysis correctly, that it improperly relied on Miller, which is no longer good law.
But counsel, you're going to the Bruin analysis, which I want to give you time to do, but at least the way I'm looking at it, the first thing we need to decide, you're giving us a lot of reasons to overrule Miller, but is that something we do before the Supreme Court does it?
Your Honor, yes. I believe that in Bruin, the Supreme Court announced that prior precedents that in any way use a means-end analysis to analyze the Second Amendment are out. I do not believe that this court can rely on Miller because I believe that Bruen has abrogated Miller. So it is my position and the position of the appellant, Mr. Rush, that it is appropriate to enter the Bruen analysis on this question.
What about Heller? I mean, Bruen explicitly said that Heller still remains good law. And so, in Heller, the Supreme Court referred to not only to Miller, but the fact that, arms like, short-barreled shotguns just don't come within the definition of arms as protected by the Second Amendment.
And I appreciate that, Your Honor, and I understand the timing here, and I understand that Bruen did preserve and certainly reference portions of Heller and Miller and their prodigy. I believe, though, what has happened is a sea change, that what the Supreme Court in Bruen really did is said that the entire framework needs to be reanalyzed. And that's not to say that certain logic and rationale from Miller is not going to come under this new analysis, that a new court could come in and say, yes, for the same reasons that Miller and the court in Miller found that short-barreled shotguns are outside of the common use or that they are dangerous and unusual, we too find that. But Bruen reset the test, and they said you can't go about it the way that courts prior to Bruen did it, and that includes Heller and Miller. You have to use this new test, and that is this two-part test. And
so what is your proposed definition of arms, then?
For purposes of the first part of the test, Your Honor, I think is it a firearm? And I think that would include short-barreled rifles.
And that's it? Just point blank, whether or not it's a firearm?
Yes. Gatling guns, machine guns, as the court has cited in earlier things that clearly have no civilian application are still firearms. I think that the...
So you would take out of that things that have only military application?
No, Your Honor. I think that if it is a firearm, it survives the first prong of the test.
Well, then why on earth is Bruen talking about common use for lawful purposes of self-defense? What's all that about then?
I think that goes into the second prong, Your Honor, where the court's going to look at the historical tradition, and I think that's where you get that guns analogous to machine guns or some of this military weaponry is not going to survive that scrutiny.
Is the turret of a tank a firearm?
I'm not a munitions expert, Judge, but I do appreciate the sensibility of the question. I don't believe anybody is advocating for machine guns and tanks to go into civilian use, but I think that
But your position is it would survive that first step.
My position is that the test that the United States Supreme Court established in Bruen and all of the problems it has caused, as this court has seen from its litigation and its sister circuit litigation, has required a re-examination of the entire framework. So I believe that, yes, that should be a question for the second step of the framework.
But as Judge Lee asked, when you're just talking about the first step, you're saying firearm. So turret of a tank survives the first step.
I think that if it is I understand, Your Honor, and I don't intend to seem inflexible by not yielding any ground. But I think that there has to be an analysis of whether it is a firearm in that first prong, and I believe that first prong analysis is exceptionally broad, that the narrow focus, the real scrutiny of the historical tradition comes into the second prong analysis.
Okay. Heller says, Miller stands only for the proposition that the Second Amendment right, whatever its nature, extends only to certain types of weapons. Heller did not abrogate that language. Heller is saying Miller still stands for that proposition. The Second Amendment extends to only certain types of weapons. How do we square what the court has said in Heller, which the court did not step away from in Bruen, with your definition of firearm? First step just means firearm. Every firearm. Not certain types of firearm. Every firearm.
Yes, Your Honor.
Okay.
I think that what Bruen did is it set aside any test or any law that was based on a means-end analysis. And I think that that's what supports my argument regarding moving directly to the Bruin test, that anything that is, premised on this means end analysis, A because of B, has to be re-examined. And I'm not.
That's not a means end statement
I know, but
that I read. It's a statement about what is covered in the definition of arm.
Yes, Your Honor. I understand. I don't have a more specific answer to your question, I'm afraid.
Okay.
So if there are no remaining questions, I will reserve the rest of my time.
Okay, Mr. Leggins, am I pronouncing it correctly?
You're pronouncing it correctly.
Okay, thank you.
Good morning, Your Honors. My name is Tom Leggins, and I represent the United States in this appeal. With all due respect to counsel, I do not agree with his assessment of Miller that it is a means end test. It is whatever you want to say about it. It is still a text and history opinion. Judge McReynolds goes through a pretty detailed, actually historical analysis of the Second Amendment as it should apply to the National Firearms Act. So at the outset, I want to make clear that I disagree entirely with counsel's premise that Miller is a means end test, which this court is just allowed to overlook.
Well, I think that, Mr. Newton does have a point to the extent that so many courts are struggling with Bruin, right? And I think the struggle comes in the fact that, number one, both Step 1 and Step 2 require some historical analysis, right? And to some extent, even, I think Mr. Newton's argument, even Step 1, whatever we may think of Miller, has some means as flavor to it, right? Because we're looking at, is it a lawful ends, right? Is it a means to something that a lawful citizen would have, to common citizen as opposed to the military? Those kind of echo kind of a means ends type of framework, which in Bruin the court disavowed. My only point is there's just a lot of overlap and fuzziness between Steps 1 and 2 to some extent.
And the court's not the only one who struggled with these particular issues. I think if this court follows the government's position that Miller is controlling, you don't even reach Bruin, which may be a saving grace, at least in this case, because if Miller controls, if this court is not free to apply Miller's holding to a short-barreled rifle, then that ends the inquiry. Now, I understand that this court probably, as the court did in Beavis, is going to nevertheless want to more fully expand on the types of issues that is concerning this court this morning. But moving on from Miller, I think even if you look at the Bruin analysis as to the questions Your Honor had, I mean, what are arms, and really it doesn't matter. I don't think it matters who has a burden of proof in this case. I think the way that the Justice Scalia construed arms in Heller, which Bruin did nothing to overturn, and the way this court construed Bruin and Heller in Beavis, then the arm at question here does not qualify for protection under the Second Amendment. What we are left with is the notion that the Second Amendment only protects those arms in common use for the purpose of self-defense. And the defendant has failed to establish that with regard to the two short-barreled rifles. There is a long history of outlawing short-barreled rifles in this country for very good reason. They're not useful for self-defense. A person could use one for self-defense, but they're not in common use for self-defense. Their main utility is that they can be concealed and that they have a large amount of power compared to an ordinary rifle. This was a sawed-off AR-15. It shoots
How would a plaintiff, or I guess here a defendant, make the showing that something is in common use for self-defense?
You know, and I guess that gets to the an issue that conceptually I have had to run around in my head with also, is that ultimately who decides what is in common use for self-defense. I think this court made a great effort at resolving that question in Beavis when this court said that the dividing line is military versus non-military. I'm not sure that that's where the issue will ultimately end up. Right now, it appears, at least in this circuit, to be a legal standard, in that the court makes that determination of what is in common use for self-defense. I'm not sure it's always going to remain that way, but right now that appears to be the law.
Well, I want to marry that with your statement earlier that it doesn't matter who has the burden of proof, because if we find that Mr. Rush did not make that showing that short barrel rifles are lawful and commonly used lawfully for self-defense, how do we marry that with your statement just now that that is perhaps a court finding?
Well, right now, and I was in agreement with Judge Lee's observation that there's some conceptual problems. The way the law stands now, the defendant bears that burden. Mm-hmm. The defendant has show, according to this court in Beavis, mm-hmm. that it is in common use for self-defense. And our position is he failed to do that for all of the reasons I go on for ad infinitum in our brief. Mm-hmm. So as it stands now, it's our position this court should affirm on the basis of Beavis, because Judge Wood in Beavis said that the defendant bears this burden, and it is our position that he has failed to meet this burden. So
but your earlier answer to my question is you don't know how he would meet the burden, but he hadn't done it. Is that your position?
Yes, that okay. Whatever that burden is. Well, he would have had to have presented evidence at some point consistent with Beavis, or he would have had to have made arguments in this court consistent with Beavis. And with all due respect to counsel, his argument is not that here's why I went under Beavis. His argument is you guys decided Beavis wrong. And it is our position that that's not what happened, or that this court, or at least that this court should not do that. That Beavis applied the framework that was dictated by Heller. This court took a look at Judge Scalia's opinion in Heller and the opinion in Bruin, and the standard is that the Second Amendment protects those arms that are in common use for the particular purpose of self-defense. And the defendant is not arguing before this court today that a sawed-off rifle is in common use for the particular purpose of self-defense. He's urging this court to find that Beavis applied the wrong standard. And on that basis, we believe that the court in Beavis got the Heller standard right, and that this court should affirm in this case because of Beavis. Or we don't even think you even have to reach the Bruin analysis again because of the Miller test that we spent the first several pages of our brief going through. So if there are no further questions from the court, I will yield the rest of my time, and thank you.
Okay, thank you. Mr. Newton, we'll give you your 3 minutes.
Thank you, Your Honor. Your Honor, just for purposes of clarity, I do believe that the appellant, Mr. Rush, did argue and has demonstrated that the firearm used in this case, the short-barreled AR-15, was in common use and was held for purposes of self-defense. and I don't believe that there is any information on the record to suggest otherwise.
Well, that's two different things, that it was in common use, and then you say for him it was for self-defense, but the standard that we have to be mindful is common use for self-defense.
Yes, Your Honor, and I think we've alleged...
Did you make that showing?
I believe we've said that as well, Your Honor. We cite to statistics in the brief that some 500,000 plus of these short-barreled AR-15s...
That, to me, were statistics showing common use, period. Not common use for self-defense. How do we get the self-defense part from the bare statistics you did cite for us in the brief?
I understand, Your Honor. I think that he has made that allegation, that he was using it for self-defense. I believe that there's been no evidence adduced otherwise that he was not using it for self-defense. I believe it is that which gets me in part to the second prong of the test, which shifts the burden to the government to show that it is outside of the historical context of regulations on the Second Amendment.
And how do you succeed on that part?
I believe that in the brief, Your Honor, we've cited numerous historical analogies to this type of short-barreled rifle that show that it was commonly possessed by people, that there were not sufficient regulations. That comes down to the historical argument we're seeing in all of these cases of a pile of cases in column A, a pile of cases in column B, and then the government and the defense bar going at each other to parse out the differences between them. But I do believe that Appellant Rush has set forth a number of examples that show that analogous weapons were in use back at the founding and at the time of the Second Amendment.
And not regulated.
And not regulated, yes, Your Honor. So if there are no further questions at this point, I would ask the court to reverse the conviction in this case, remand the matter to the district court to allow Mr. Rush to withdraw his guilty plea, and instruct the district court to dismiss the indictment on the basis set forth here today.
Okay.
Thank you.
Thank you, Mr. Leggins, Mr. Newton, and we'll take the case under advisement. We're done for the day.